Hi there, in this video, we'll talk about whether or not Amber Heard has a basis for appeal and how does the appeal work, especially after a juror has broken his silence and spoke out as to what happened during deliberation. So stay tuned! Hi there, my name is Katherine. I'm a lawyer and I also think differently. We've heard Amber Heard and Elaine Bredehoff go on interviews after the verdict saying that they will appeal the jury verdict. The appellate process is different than the trial court process. I used to be an extern for the Ninth Circuit Court of Appeal, which is the federal court of appeal level right below the U.S. Supreme Court. But here, the Johnny Depp and Amber Heard trial was a state court case. So the appeals process will go up to Virginia Court of Appeal. Why is that? That's because for the appeal, 3 appellate court judges will hear the case, as opposed to here in the trial of Johnny Depp and Amber Heard, it was the jury who heard it. So in the Court of Appeal, what would happen is you can only appeal on 2 bases, which is there was an error in the legal ruling or there was an error with the evidence that was presented in the case. An appeal doesn't mean that you get to retry the case in front of the 3 appellate court judges. It actually means that the appellate court judges would look at what happened in the trial court or the lower court, they call it the lower court below, and figure out if there was any error that happened in the lower court that rises to the level of appeal. There are different standards of review for appeal when you're on the Court of Appeal. For the legal ruling that I mentioned, that usually talks about jury instructions. Were there any issues with the jury instructions? Were there any issues with any of the law that was given to the jury? As opposed to evidence, any issues with the evidence? Were there evidence that were excluded or should have been included? So the evidentiary rulings that Judge Ascarati made will be put at issue if there were anything that would rise to the level of appeal. So just because Amber Heard's legal team did not agree with one of her rulings doesn't mean that makes it appealable with the Court of Appeal. Also, there were motions in limine that happened before the trial started. Motions in limine are arguments or briefs that both parties present to the court and are argued before Judge Ascarati outside the presence of the jury. Those deal with specific legal issues, procedural issues that the judge then rules on before the trial actually starts to streamline the trial as to what evidence will come in and what evidence won't come in. So those are part of the evidence issue that could be raised on appeal. Now, the motions in limine are not available to the public. They were not posted in the court link, so we don't know what those motions in limine are, so I won't be talking about that here. What's interesting about Elaine Bredehoff's and Amber Heard's interviews after the verdict is it seems that they're trying to bait the jurors to respond to what they're saying, possibly to create a reason for appeal. And as we see, one of the jurors actually spoke for the first time, most likely because he felt deeply offended with what Elaine and Amber have been saying, especially questioning the jury's credibility and oath that they took that they will not use or look at social media and that they would only look at the evidence. Even I, as a lawyer, was deeply disturbed, and I've said this in the media as well, as to how Elaine Bredehoff, a lawyer herself, could question the jury system or the jurors themselves without any basis to say that they looked at social media and was influenced outside of the 4 walls of the courtroom and that they violated their oath. That is very insulting for our legal system. As I mentioned, one of the male jurors has spoken out and gave a statement to ABC. One of his statement, it could be an issue for appeal, and I'll tell you why. This is what he said. What I think is truthful was that they were both abusive of each other. When I first heard that, I thought, oh no. The reason is because I believe Amber Heard's legal team will definitely try to use that against, not necessarily the juror, but against the jury verdict. The reason is because if the jurors believe that both of them were abusive, then that could be interpreted as Johnny Depp was abusive to Amber Heard Heard, but even though they believe that, they still considered the statements in the op-ed as false and defamatory. So taking that statement by itself, that we believe that they were both abusive, that could rise to a level of appeal as to the legal rulings in terms of the jury instruction. But we cannot just take the juror statement by itself, and I'll tell you why. Notably, that juror also stated that, but to rise to the level of what she was claiming, there wasn't enough or any evidence that really supported what she was saying. What that juror is trying to say is, there's no evidence that rises to the level that she is claiming that Johnny Depp physically abused her based on her lack of credibility, based on the evidence that were presented, based on the pictures that were shown. So you wonder if the juror is thinking they were both abusive in a sense that they were verbally abusive to each other, but it does not rise to the level of domestic violence, and most importantly, it does not rise to the level of sexual abuse that Amber Heard testified to at trial and claimed as part of her op-ed. In fact, the juror noted that he believed that Johnny Depp did not hit Amber. I wonder if all the other juries felt the same. I think the answer would be yes, because all unanimously concluded that the op-ed was indeed defamatory. If Amber Heard's team uses what that juror stated as a basis for appeal as to the legal ruling, meaning there was an issue with the jury instruction being confusing for the jurors, then the standard of appeal would be what we consider de novo. De novo literally means from the new. From the new, meaning it doesn't mean that there's going to be a new trial. What that just means is that appellate court judges will look at the evidence that came in at trial, and then they will use their own inferences and their own judgment in coming up to a legal conclusion. That's what de novo means. So with the de novo ruling, it will be as if the evidence are being heard for the first time without deferring to what Judge Ascarati ruled on those evidence at the lower court trial. But again, it does not mean that it's a new trial. Now, if Amber Heard's legal team says, look, that juror said that based on the evidence, there was not enough evidence to show that any physical abuse or that Johnny Depp hit her, if that's the legal argument that Amber Heard's team will use as to evidence that came in or did not come in, the standard of review in the appellate court level would be abuse of discretion. And in abuse of discretion, the appellate judges will really defer to the trial court because they're the ones who are there, and especially this is a jury trial, so the appellate court will give a lot of deference to the jury verdict. But if Amber Heard will be attacking Judge Ascarati's specific rulings as to objections that they've made and raised, and Judge Ascarati sustained or overruled, or any evidence that she didn't allow them to come in, so the appellate court will look at it as to whether or not Judge Ascarati abused her discretion in allowing or not allowing the evidence to come in. And we saw how Judge Ascarati ruled on the bench. I think for me personally as a lawyer, I feel a lot of deference to her, and that her ruling were very sound and really had proper basis. As to the motions in limine I mentioned before, which are arguments that both sides would have presented in writing and argued orally in front of the judge without the jury's presence, I don't know what she ruled on those because they are not available for the public to read. But those could also be a basis for appeal. Elaine Bredehoff has repeatedly stated as well after the verdict and during her post-interviews that the UK decision should have come in for this US trial. But the UK decision is really what you considered irrelevant. That's because whatever the judgment was in the UK has no bearing here in the US. Now, for the law nerds and law geeks like myself, there's this term called res judicata. What that means is that it's a principle that a cause of action cannot be relitigated, and that there should be a finality when certain issues or parties go into each other. That's because you don't want to relitigate and sue someone over and over again because of whatever happened in the past. We want that one cause of action that once you sue someone and there's a judgment or there's a settlement, that's done. That's it. We can all move on. So I think what Elaine Bredehoff or Amber Heard's legal team is trying to argue is that the UK decision should be dispositive or should affect the US trial, because if Johnny Depp was found found to be a quote-unquote wife beater there, then he should be found a wife beater or actually did physical abuse or sexual violence against Amber Heard here in the US trial. But again, that's not necessarily the case because the legal concept of res judicata, it requires 4 elements. And one of the elements that is really missing here is that the parties in both of the cases has to be the same. And everyone knows that the UK trial, Amber Heard was not a party to that. It was just Johnny Depp versus the Sun. And then here in the US, the party is Johnny Depp versus Amber Heard because Amber Heard wrote the op-ed. And Johnny Depp could not sue Amber Heard in the UK trial because Amber Heard did not write the article in the Sun. The Sun merely mentioned Amber Heard because of the wife beater. Also, a very important thing to remember is that the UK trial happened in UK, the US trial happened in US. They're both different countries, and each country respects their own judgment, but that doesn't mean that country A will automatically follow what country B's judgment is and vice versa, unless there's a treaty that would allow both countries to reciprocate or interpret both judgments to be applicable for both of them, which I am not aware is the case here, and I highly doubt that's the case here, and the UK judgment is really irrelevant to the US trial. So what does Amber Heard need to do if she wants to file an appeal? First of all, she has to file a notice of appeal, and in Virginia, she has 30 days from the date that the judgment is entered to file a notice of appeal. It's not 30 days from the date that the jury reached their verdict, and the judgment is the written order that the judge will enter in this case. When the jury reached their verdict, Judge Ascarati said to Ben Chu, please go ahead and write the order, and then what Johnny Depp's legal team will do is they'll write that judgment and then show it to Amber Heard's legal team, and there will be a lot of back and forth objections as to how it should be worded, and then it'll be given to Judge Ascarati for final approval, and then she will sign it and enter it as the final judgment in the trial court. Only when that is entered, meaning stamped, filed in her court, that's when the 30 days start ticking for Amber Heard to file a document called a notice of appeal. Together with the notice of appeal, Amber Heard must also post an appeal bond. In Virginia, there is actually a new law that came out on January 1st, 2022 of this year that would be applicable for her case. And I'll cite that actual law. It's Title 8.01-676.1. That's the security for appeal. And what that says is that the appeal bond is $500 or such sum as the trial court may require, subject to subsection E of that code section. And that subsection E code section, there's a lot of different rules there, but what I wanted to point out is the subsection E just basically says if a party files a motion for the bond to be increased or decreased, then the trial court would have to consider that motion and resolve it or modify the $500. So we'll see if Johnny Depp's side will file a motion to increase the bond, but I highly doubt it because they always maintain, Johnny Depp and his legal team always maintain that this is not about the money, so I doubt that they will increase that bond. And also, I highly doubt that Amber Heard will ask for the $500 bond to be decreased because it's $500, and if she can afford a private jet after the trial, I think she can afford $500. This kind of subsection E of asking for the bond to be lower is reserved more for appellants who don't have money and who really just wants to appeal their case, and we don't want to prejudice them by not allowing them to appeal their case if they didn't have $500. And $500 for a lot of people is a lot of money. That's why the law allows them the opportunity to request the court to lower the appeal bond so they can go ahead and file an appeal. What that means is for Amber Heard to file a notice of appeal, she does not have to actually post an appeals bond of $10 million of compensatory damages and $350,000 of punitive damages, which the jury awarded to Johnny Depp for all of the 3 statements that were considered defamatory, hence was in favor of Johnny Depp. Similarly, if Johnny Depp wants to appeal the jury verdict where they found one of Adam Waldman's statements was defamatory and how they awarded Amber Heard $2 million for that statement, Johnny Depp does not have to post $2 million to to file an appeal. Both Amber Heard and Johnny Depp will just need to file a notice of appeal and an appeals bond of $500 per Virginia rules for Court of Appeal. So that's the quick version of the appellate system. There are more intricacies as to that. Right now, what we really have to focus on is whether more jurors will come out and what other statements the jurors will make. I would highly suggest that the jurors don't come out yet until certain time has already passed so that their statements cannot be used by Amber Heard's legal team in support of their appeal, or if they want to really break their silence, to be very careful of the words they use, because unfortunately Amber Heard and her legal team will use their words against them. And I highly respect the jurors that participated in this 6-week trial, and I think that they really just looked at the evidence and they took their oath seriously, especially since they actually found one of Adam Waldman's statement as defamatory. If they were so enthralled about Johnny Depp and the way Amber Heard is claiming that he's a powerful man and basically is claiming that the jury were gullible and fell for Johnny Depp's charm, well, they still awarded her $2 million, which tells me that they really looked at the jury instructions and really parsed it out and took all of the statements seriously and came to their conclusion as to the verdict for each of them. If you learned something new from this video, go ahead and click subscribe. As you know, my son created this for me in support of my YouTube videos, so please go ahead and click subscribe and let me know in the comments below if you have any other questions, especially about the appeals process. So hopefully this is helpful for you, and see you again soon. Bye! Thanks for watching!